Hello, good morning, good afternoon, and good evening to everyone, depending on where you are joining us from today. My name is Karis Tan. I'm a partner at Peter & Kim in Singapore, and I will be your moderator for this panel. Now, I'm extremely pleased to welcome you to our webinar on international law and principles of sustainable business. Where the idea for this panel came from is that public international law has traditionally been the mainstay of state actors and governments. But the reality today that we see is that international law is increasingly permeating how we conduct ourselves in industry, commercial transactions, and business. So this is why sustainability and the longer term of business practices needs to be considered. And in particular, the focus that we're taking today is the lens of international law. We are very privileged to have with us today 4 speakers. They are going to take us through the applicable principles from 4 different perspectives. And I've had a bit of a hint as to what they're going to talk about, and we are in for a real treat. Now, first, Professor Laurence Boisson. She is a professor at the Faculty of Law at the University of Geneva. She is also director of the Geneva LLM in International Dispute Settlement. She directs research projects at the Institute of International Law. And if that is not enough, she also acts as an advocate and counsel. In fact, I first got to know her through our days representing a state before the ICJ. She has also acted as counsel before ILA, served as chairperson in WTO panels, and an arbitrator in investment arbitration. Now, next, we have with us Professor Anita Ramasastry. She is the Henry M. Jackson Professor of Law and Director of the Sustainable International Development Graduate Program at the University of Washington. So really, she is perfectly suited for speaking to us today. She has been a member of the United Nations Working Group on Business and Human Rights since 2016, and she leads its work on topics such as the financial sector, human rights due diligence, business, and conflict. And we are extremely grateful to her for joining us, particularly because it is right in the middle of the night for her. So thank you, Prof. Third, we'll have Mr. Gareth Hughes. He worked with us on the previous panel on sanctions, and he was absolutely excellent. So of course, we had to invite him today. He's a partner at Debevoise and Plimpton's Hong Kong office. His practice focuses on major commercial litigation, international arbitration, white-collar crime, and regulatory defense matters. He has had over 25 years of experience in the region, advising major corporates, financial institutions on proceedings in the courts or before arbitral institutions. He also frequently advises on internal and regulatory investigations. Now, last but not least, Dr. Romesh Riyamantri, who is the head of International Dispute Settlement at the Center for International Law at NUS. He's also an adjunct professor at the NUS Faculty for Law. Now, Romesh is so talented that he needed to add an extra hat to that. So in addition to those, he's also a senior consultant at Clifford Chance in Singapore, and he specializes in international commercial arbitration and investor-state disputes. He was previously a legal officer at the UN Compensation Commission and a legal advisor to the president of the Iran-US Claims Tribunal. He's also published several books, so I will not list as there are too many of them. Now, how I intend to conduct today's session is that first we will have presentations from each of our 4 speakers. Laurence will focus on business and the environment. Then she'll be followed by Anita. Anita will take us through business and human rights. Gareth will bring us into business and sanctions, and then Romesh will wrap up with business and corruption. After that, drawing from their presentations, we'll have a session of panel discussion, and that's also where we'll be grateful. We would love to have your comments, any questions. That's where we'll pick it up, and we look forward to a very engaging session. Now, without further ado, let me hand over to Laurence. Laurence, please.
So good. It's nice to see you all, and many thanks for Caris for her invitation. It's true that we worked together a few years ago, and it was a pleasure. So I'm going to be starting with presenting the role and the relationship between business and the environment. And I think it's a nice way to think about the fact that next year, in June 2022, we will be celebrating the 50th anniversary of the Stockholm Conference on Human Environment. It's going to be in Stockholm in June 22. And this offers us an opportunity to think about, but what's the role and the place of the business in the field of environmental protection? And I'd like to start with saying that, in fact, the private sector has always been there. And the private sector has been considered as a key actor in the context of the negotiations of environmental instruments. It's interesting to note that even in Stockholm in June 1972, when the UN was convening the first ever conference dedicated to the environment, 4 categories of actors were invited: the states, obviously, international organizations, associations, scientific associations, and the private sector. So I highlight this because I think it's something which is, I think, very significant in the field of environmental protection. So that's the first point I'd like to make. Then if we move along, we have the Rio Conference on Environment and Development in June 92. And in June 92, this is really the conference about the protection of the environment in the context of development. And there too, the private sector is there. It is invited, and it plays a very significant role for launching new initiatives. And what I think is interesting is that the states, the negotiators, when they're going to be negotiating instruments in relation to environmental protection, they're going to be thinking about the role of the private sector and what it should be doing, what it can do, both at the domestic level and at the international level. And when I was thinking about this presentation, I went back to the Climate Change Convention that was open to signature in Rio. And it's quite interesting to see that the Climate Change Convention has a lot of provisions in reference to what the private sector should be doing. It's the same for the Biodiversity Convention. Maybe now, as a footnote, when I'm going to be referring to business or to the private sector, I would like to say that it's a generic notion, because in fact, public entities also should be considered in the context of what we call the private sector. So it can be public or private entities involved in business activities. So to come back to Rio, the 2 important instruments were open to signature: the Climate Change Convention, as I said, having provisions dealing with the private sector, as well as the Biodiversity Convention. And we often forget that the Biodiversity Convention wanted also to frame, to shape the role of business. Interestingly, also, the subsequent instruments which were adopted, I think of the Kyoto Protocol, speaks to the private sector. So it speaks to the private sector referring to the legal entities, but in fact, legal entities are business activities. The same with the Cartagena Protocol on genetically modified organisms, or the Nagoya Protocol dealing with the sharing of benefits. So what we see is that the private sector, from a normative standpoint, is considered as an important actor. And what the legal instruments framing what should be environmental protection are going to do is to sort of identify the role, the rights, the obligations of the private sector in areas such as climate change or biodiversity protection, but there are other areas. Now, what I think it's worth noting in this context is that states are saying the private sector should play a role. And in this context, they're asking the states through their domestic orders to make sure that the private sector will abide to certain rules and principles. So we're going through the domestic orders to make sure that environmental protection is guaranteed by the private sector. Now, moving along and looking at what has happened afterwards, as from the 2000, it's quite interesting to see that at the international level, there is a willingness to speak directly to the private sector. So to speak directly to the private sector and to consider it as an international actor. So I'm thinking, for example, of the Paris Agreement on climate change and the decision of the Conference of the Parties that was adopted at the same time than the Paris Agreement. And there, if you look carefully at the documents, you will see that these documents speak to stakeholders, other stakeholders, and in fact, other stakeholders, it's mostly the private sector and the alliances that they should be doing. And we think about what is going on in Glasgow, and I'm sure that all the colleagues who are in Glasgow are going to notice that the private sector is everywhere. Okay, so it's interesting because there we have a new way of sort of interacting with the private sector, is that to speak to the private sector from an international perspective. And I think that another very good example is the UN agenda for sustainable development. It's the 2030 agenda for sustainable development, which has endorsed the 17 sustainable development goals. Okay, and there too, it's interesting to see that there is this willingness to engage the private sector, directly. In my notes, I had put to capture the private sector. I don't know if it's capture, but it's the idea that they should be on board. I think it is because we know that the public funding is not sufficient. And also the technological knowledge is also crucial for improving what we're going to do with environmental protection. So there, when we look at these documents, I think what is interesting is that these documents are no more looking at domestic law as for sort of conveying for making sure that states are going to guarantee that the private sector behaves accordingly to the instruments. When we look at these instruments, we see that there is no more intermediation through domestic orders. It's through legal instruments that the private sector is engaged. And preparing this lecture, I was thinking that obviously, there are a lot of criticisms that we can do with respect to what is happening with the SDGs, but there is also hope that something is going to happen. And we work in Geneva, more particularly on the SDG 6, which is dealing with access to water and sanitation. And when you look at the figures, you know that without the private sector, we will not be able to provide access to water and sanitation to everybody in 2030. So this goes with certain responsibilities, and that maybe something I would like also to shape is that this new trend that we see is that there is a direct engagement with the private sector. At the same time, there is a request for responsibilization at the international level of the private sector. And responsibilization means that the private sector should behave in accordance with certain standards. Okay. Now, in the field of environment, we have certain standards as enacted in the legal instruments, but what I think is interesting is that these standards are also framed both by states and the private sector, because we have a great number of public-private partnerships which are created in the context of which the private sector is going to commit to do a few things. So, for example, in the field of water, I'm thinking of the CIL water mandate launched by the UN Global Compact. And there the business leaders have, in fact, through commitments endorsed certain behaviors that they should follow. And it's interesting that in the context of the CIL water mandate, there is also a request by the private sector to provide progress reports. So that we will come back to that, but I think it's very important to also have this monitoring in place. We have also a guide to responsible business engagement with water policy that has been framed and endorsed by business leaders. So what we see is with this new trend, and I think we're going to stay with it, it doesn't exclude the one that rests on the sort of domestication of the context of private sector, but at the international level, there is a request for responsibilization, and the private sector does this through unilateral commitments. Okay, and I think for us international lawyers, the question is, but so what's the nature of these unilateral international commitments? And then if you make a commitment and the status of which is not yet clear, the question will be, but how to take the private sector to its words and how to make sure that what you've committed to, you're going to do. And there, it seems to me that a lot is resting on the reputation, monitoring, the publicness issue, because it's known to everybody. So it's thought that the peer pressure is going to play a role. So that responsibilization is going to be to play a role. But I think the question is it sufficient? Is it what we want from a legal viewpoint? I think from a policy viewpoint, it's an interesting laboratory because it shows that the private sector is at the forefront with the other actors. But there is a big question as how to make sure that commitments are fulfilled. And in this context, I think what is interesting, and we're going to hear Anita, is to wonder if the principles has designed in the field of human rights could play a role and could give sort of a normative backbone to the commitments that have been made in the field of environment. So with these few words, I will end my presentation. Thank you very much.
Thank you so much, Laurence, for that very insightful presentation, in particular on how there has always been this willingness to speak to the private actors. Now, Anita, take us through the backbone. We're looking forward to it. Over to you.
Great, thank you so much. And I'm going to be speaking about, I think, the odd topic out in this discussion. If we look at public international law, in the area of environment, and I'm a banking lawyer focusing in my own work on corruption and sanctions, if we look at those three topics, there is public international law. There's hard law that really constrains or deals with businesses that are meant to help them act responsibly and sustainably. But the area of business and human rights is a sort of interesting field because it's one where we don't have that strong backbone of public international law. So I'm going to talk about the challenges of business and human rights and the UN guiding principles of business and human rights and why we have them. So the UN guiding principles in business and human rights were endorsed by the UN Human Rights Council in 2011, and we've just celebrated their 10-year anniversary. And I want to just spend a second to pay tribute to Professor John Ruggie from Harvard, who was the architect of the guiding principles, and he passed away last month. But he left us with a very pragmatic framework that was a combination of hard law when it came to state responsibility, but soft law when it came to business and the way in which business needed to address human rights globally. The reason we have the guiding principles is because of what Professor Ruggie called governance gaps in international transnational law and economic activity. We think of them very much today when we think of global supply chains, for example, and perhaps forced labor that may happen somewhere in the world in a factory where workers are producing goods that are going to be consumed somewhere else in the world. And so companies that are procuring those goods and services, the question is, when there's a harm somewhere else in the world, what responsibility do they have? Or if we think of a mining or extractive company, again, the parent company is headquartered somewhere, maybe Canada, maybe the US, but the impacts to victims or rights holders are somewhere else in the world. And over time, from the late 1990s until the time we enacted the guiding principles, there was a large push from civil society globally to say, what responsibility should businesses have for that transnational harm in terms of human rights? And the answer was very gray because there was no specific binding obligation for business as a non-state actor. So of course, domestically, if you're in a jurisdiction where law is strong and protects you as a worker, as a consumer, as a rights holder, you'd have recourse, you'd have remedy because you'd have a strong court system, but also strong national law. So business and human rights is really about governance gaps. But just to remind everyone, the UN Human Rights Council endorsed an instrument or a framework that was not a binding treaty. The guiding principles on business and human rights, it's my job as an expert, a member of the working group on business and human rights to implement them, is focused on three key pillars. The first one, it's called the Protect, Respect, and Remedy framework. But the first pillar of the UN guiding principles, which again is a framework, not a convention, focuses on the state duty to protect, meaning that states, of course, have a pre-existing duty under international human rights law and international law to protect us from harm. And usually that's harm from the state, right? We shouldn't be tortured. We shouldn't be arbitrarily detained. But that duty also includes regulating companies within a state's jurisdiction to prevent them from doing harm. But the question has always been, well, does that extend extraterritorially? And the guiding principles said maybe, but didn't go as far as to say always. So pillar 2 of the guiding principles focuses on respect for human rights. And what Professor Ruggie did was he said, okay, the challenge is that laws vary all over the world. And so global or transnational corporations are really not providing uniform and consistent respect for human rights and the people they impact around the world because of these different laws. So we're going to ask companies to respect human rights by benchmarking their conduct against international human rights laws, against core treaties, the Universal Declaration, ILO standards, and the 2 covenants on civil, political, and economic, social, and cultural rights. And this is a major pragmatic move, even if it's considered soft law, because Pillar 2 is not binding under the UN guiding principles. But the idea was that businesses were meant to commit to this, a sort of international standard, and they were meant to use a process that we refer to today as human rights due diligence to basically look at their business operations, not just their direct relationships, but their general business relationships, and identify those impacts that they need to prevent, mitigate, and then if they're in certain circumstances, provide access to remedy. So in today's world, we're very much focused on global supply chains as a key issue. And the G7 actually just last week issued a strong communique focusing on a commitment of those governments to human rights due diligence and to issues of human rights in global supply chains and the guiding principles. So the real issue here is will we ever reach a stage where these commitments are binding? The UN Working Group on Business and Human Rights is really focused on this topic because we've just looked at a decade of implementation of the guiding principles. What have states done? Because again, we have Pillar 1, Pillar 2, and I should have mentioned Pillar 3, which is about states and business providing victims access to effective remedy. But the question is, what has changed by virtue of this framework and this exhortation for businesses to do more to respect human rights globally? A few things have happened. One is that states using Pillar 1 have gone into much more of a hardening of soft law. That when John Ruggie wrote the guiding principles, he spoke about the fact that states needed to basically oversee corporations by using a smart mix, a little soft law, some incentives, but also when appropriate regulation. What we've seen over the past decade is we're moving towards hardening, where now, through the European Union's announcement, through national laws in France, Germany, the Netherlands, and others, mandatory human rights due diligence, where you have regulation coming in requiring companies of different sizes doing business in those jurisdictions. So again, these laws have extraterritorial and broad reach, meaning that companies now will have to mandatorily look into their business operations, have human rights plans, mitigate the impacts they have in their supply chains, in their investment activities, and provide remedy in certain circumstances. So we're seeing, right, this shift into binding law. We have treaty negotiations underway. What will happen in the UN is hard to say on a binding treaty on business and human rights. Whether it's successful now or not, that conversation didn't exist a decade ago, so the guiding principles have focused on the role of public international law. And so I would say that we've seen a shift, and the guiding principles have helped us think about what binding international frameworks could be and should be. And so they've had a tremendous impact in that way. I'll just reflect a minute, though, on the larger goal. The topic of this discussion is sustainable business. And I just want to focus for a moment on what we also heard from Laurence, which is about the Sustainable Development Goals. And I'll reflect on environment just for a second when I conclude. But the Sustainable Development Goals are also a soft law framework. I mean, governments have made a commitment to certain goals by 2030, but there's no binding convention on sustainable development. There is instead a general commitment of UN member states to this. And the SDGs are innovative, as Laurence mentions, because Sustainable Development Goal 17 invites partnerships and invites business to the table as part of this larger goal of sustainable development, which is quite groundbreaking. All of this is good, but the question is, what role does business play? Business is invited in to provide financing and to pick goals, as I would often say, cherry pick goals that are consonant with their own business enterprises. A company in food and beverage might choose a nutrition goal. A company that deals with technology might decide that education and the digital divide is where they're going to actually invest. But is that enough? The Sustainable Development Goals are a soft law kind of framework that's very appealing to the private sector because it allows them to say that they're doing good and to choose how they do good, sort of corporate social responsibility with the UN logo. And I'm not undercutting that. I teach it and write in the field of sustainable development. But a key message is that one of the biggest contributions that business can make to sustainability is through respect for human rights and through using the UN guiding principles. That the idea of doing no harm, which is what the guiding principles are about, do no harm, mitigate adverse negative impacts, is one of the most fundamental ways business can contribute to sustainable development. So the Working Group on Business and Human Rights has said that business needs to factor in both negative impacts as well as positive ones when we think about their operations. That when business identify negative impacts, for example, gender discrimination in the workplace, forced labor in their supply chains, and they use the UN guiding principles and due diligence to identify and mitigate these larger harms, this goes a long way towards sustainable development. And you can actually peg doing no harm to goals such as SDG 5, gender equality, or SDG 8 on economic growth, which has a specific goal on ending forced labor. So identification of key human rights impacts by business is consistent with the UN guiding principles, but more importantly, consistent with sustainable development. So we spend a lot of time talking to businesses about the fact that it's not either or. You don't choose the SDGs versus the UN guiding principles. You see respect for human rights as a key underpinning of sustainability. And I'll just conclude in saying that, a key message that we have for the private sector is that there's a need for a human rights-based approach to sustainable development. And I'll put in the chat, we have 10 key messages we presented to the Human Rights Council on how the UN guiding principles connect to the SDGs. And the last point, of course, as we are here during a week with a tremendous and historic meeting in Scotland around COP and climate change, is that environment has impacts on people as well as on the planet. And the SDGs, of course, is part of that. But the guiding principles really do also ask companies to think about the impact of their environmental activities on people as well. So the guiding principles and what the EU is doing is saying we need consolidated human rights and environmental due diligence. That's where the EU is moving, to think about these issues holistically. And I think that's the right approach. And I'll look forward to the discussion and hearing from our co-panelists, and thank you so much.
Thank you so much, Anita. That was a power-packed presentation. I think you gave us a lot of topics, a lot of thoughts to unpack later during the discussion. Now, Gareth, moving from soft law to hard law, that's a great juncture for the juxtaposition, and over to you.
Great, thanks, Karis. Just to say at the beginning, thank you very much to you and the whole team at ILA for putting together such a fantastic panel. It's pretty daunting following those two fantastic and interesting and insightful presentations. It's obviously a fascinating topic, a topical area, and it's an absolute honor to be part of it. I should also say, Karis, thank you very much for the warm introduction at the beginning. Just for the sake of completeness, we did speak together maybe 2 months ago now, and Karis was absolutely phenomenal and during that. So it's great to be sharing a panel with her again, and I very much hope that in the not too distant future we can share a panel in person. Turning to the topic, as Gareth mentioned today, I'm going to look at sanctions from the viewpoint of the business world. Now, obviously, international sanctions are nothing new, but it's obviously an area that has had increasing prominence over recent years, with sanctions being used increasingly by various nations, most notably the US, but not only the US, many other nations as well, to further their geopolitical objectives. Now, given the wide-ranging and broad application of sanctions, it comes as no surprise to anyone that it's an area that can have a significant impact on any business, in particular if you get it wrong. And it's clearly an area that, in the context of today's discussion, has a significant impact on sustainability. And I'll come on to look at that, but before doing so, I thought it might be helpful to just recap in the first instance what sanctions are, who they apply to, and the consequences of non-compliance, because I think that helps shape the manner in which sanctions impact on the business world from a sustainability perspective. As part of that, I'll also look at various practical steps that businesses need to take to ensure that they comply with sanctions. And then finally, I'll come on to discuss sustainability. So the first topic, what are sanctions, who imposes them, and what do they apply to? Well, obviously, that is a whole topic and seminar in itself. So I'll just highlight a few key points. I mean, the first is that ultimately, given the diverse nature of sanctions and the way in which they're imposed, there isn't one size fits all. That said, in general, economic and trade sanctions will usually involve some form of restrictions that are imposed on various types of transactions with specified countries or persons as a means of assisting the nation or body that's imposing them to help secure their foreign policy objectives. Those restrictions can obviously take many forms, but in general, they'll usually involve some element of embargo or prohibition on certain activities, most frequently trade-related. Potentially some level of financial sanction, which again can take many forms, but can involve the imposition of tariffs, the blocking of assets, the prohibition on provision of financing, etc. Who imposes sanctions? Well, generally it's either international organizations such as the EU or the UN, for example, as sanctions against North Korea, or by individual nations or some combination of the two. And in terms of targets, sanctions will be directed against, first of all, other states, including their public authorities within those states, against specified individuals or organizations within the states, and against specific subject matters, for example, vessels and aircrafts. And there are, of course, many reasons why they're imposed. Although most frequently they're introduced in order to counter such things as anti-terrorism, arms trading, drugs traffic, and human rights abuses. More generally, they can be imposed when a nation believes that steps are required in order to protect its national interests. And so they usually involve some element of, want of a better phrase, of ethical imposition, and by which one nation seeks to persuade or deter another nation from carrying out activities which the imposing nation believes to be improper. Although, as you will know, such ethical judgments are frequently not accepted or acknowledged by the sanctioned state, which in itself can cause significant issues for businesses dealing with them. And in this context, it's worth noting that, as with many areas of international law, there isn't a single approach to sanctions. And whilst there frequently can be cooperation between nations, that isn't always the case. So you'll frequently end up with sanctions issued by one state contradicting sanctions issued by another state, receiving states imposing counter-sanctions, or even anti-sanctions legislation, as we've been seeing used more recently, to prevent compliance with any sanctions that have been levied against a state. So the world of sanctions can be a political and commercial minefield. That leads neatly into the question, well, who's going to have to navigate that minefield? Who has to comply with the sanctions? And unsurprisingly, again, that's very, very broad. In large part, it will be determined by whether the sanctions are primary or secondary. As regards primary sanctions, compliance will generally be required by all national, citizens, or corporations of the sanctioning state, in addition to local and foreign businesses which are carrying out business in the sanctioned state. But some sanctions, which are known as secondary sanctions, go further than this. And secondary sanctions are intended to prevent third parties from trading with countries that are the subject of sanctions issued by another country. And for these purposes, third parties are individuals or corporations, citizens that are not based in or a citizen of the issuing nation, but who will nevertheless face a penalty for doing business with sanctioned targets. So obviously the applicability of sanctions is extremely broad. And what happens if you get it wrong, you fail to comply with sanctions? Well, again, that's case specific, but unsurprisingly, the consequences are very serious. It can involve punitive fines, criminal sanctions, including for individuals, reputational damage, and ultimately being precluded from carrying on business. So that's the framework. What does all that mean at a practical level for businesses seeking to navigate the issues that arise? Well, I've said that, certainly in my view, the area of sanctions is a minefield, and it truly is. And it can cover all sorts of areas. So let's assume you enter into a contract with a counterpart overseas. Are you confident that that counterpart or its relevant related entities are not under sanction? What about if you ship your goods on an airline? Are you confident that airline isn't the subject of some form of sanction? What about if you're a bank and you hold accounts for politically exposed persons who are the subject of recently imposed sanctions? Or if you're dealing with a non-sanctioned intermediary, the ultimate recipient of your services is sanctioned, and so on. The list goes on. All of these could easily lead to breach of sanctions and therefore liability. So what do you do? Well, the key is risk management, having appropriate policies and procedures in place to address those risks. In this context, in May 2019, OFAC published what it called its Framework for Compliance Commitments, which provides pretty comprehensive guidance on its expectations for the design and implementation of an effective sanctions compliance program. And in summary, this covers 5 key areas. I think probably the first and most important one, certainly in a business context, is it requires a commitment from senior management to promote a culture of compliance and to provide appropriate resourcing. And so here, the expectation is that senior management are accountable for securing compliance with sanctions. And for these purposes, it obviously goes without saying that senior management need to know their business inside out. So they've got to have a full grasp on the territorial presence of their business, because obviously sanctions can be applied to particular countries. They've got to understand their products and services, just in case sanctions have been applied against those services or the financing of those services. They've got to understand their workforce, given that their employees themselves could be subject to additional sanctions simply because of their nationality or presence in a particular jurisdiction. And management have to understand their business partners, which includes vendors, service providers, brokers, customers, the whole gamut. The second plank of OFAC recommendations is that businesses need to ensure that there are processes in place to carry out the appropriate risk assessment, including ongoing periodic reviews of the risks that are posed by specific countries, products, or geographies. And again, what does that mean in practice? Well, it includes the need to have in place appropriate systems, methodologies, to carry out due diligence on all employees and business partners, in addition to keeping abreast of sanctions and any changes as and when they happen, so that the business can adapt as appropriate. Now, obviously that's onerous, but as I'm sure you'll be aware, there are many online resources available to carry out research, including resources from OFAC and other governmental bodies. Although given the complexities, businesses will frequently engage third-party experts in this area, including the Big Four or local law firms, to ensure full compliance. And increasingly, we're seeing risk management officers being appointed to address these very issues. OFAC's third recommendation is the need for appropriate internal controls, including written policies and procedures. And it goes without saying, first, that those policies and procedures are not just written and then put on a shelf, but that they are actually implemented and applied from the top down, but also that they're adaptable and that they react to and respond to any changes as and when they happen. Fourth, OFAC recommends testing and auditing with independent assessments of the effectiveness of the systems and controls, and to ensure that the policies and procedures are working and are being implemented. And fifth and finally, OFAC recommends periodic training, usually annually, to ensure that all key stakeholders, employees, have the knowledge required to identify the red flags and ensure sanctions compliance. So that's the framework. They're the risk mitigation measures you can take. What in the context of today's discussion does that mean in the context of sustainability? Well, I said at the beginning that the imposition of sanctions usually involves some form of ethical objective, by which nations are frequently will use sanctions to address some form of behavior that they at least believe to be wrong. And so at its highest level, compliance with sanctions by a business helps to promote a more sustainable business. But is that necessarily the case? Well, interestingly, in a research paper published, albeit some time ago, but I think still interesting and relevant, by Oxford University's Erica Moret in 2012, she concluded that the past 2 decades have seen widespread acknowledgement by sanctions scholars and policymakers alike that the civilian pain caused by comprehensive sanctions outweighs any political gains that may be achieved. And I think that's quite an interesting conclusion. And arguably that analysis flows through to the issue that we're discussing in the business world, with certain commentators arguing that sanctions can actually often make businesses less sustainable. That's for many reasons, but in this context, whilst the imposition of certain sanctions will generally garner almost widespread international support to counter the activities in question, as I flagged earlier, that's not always the case. So sanctions are frequently seen as an attempt by one nation to impose its views of what ethical or appropriate behavior is on another nation, which in turn can often leave a business caught in the middle of a political crossfire, as part of which sanctions are being used as the main weapon. And the consequence of this, of course, is the sanctions minefield that I've discussed, which in turn can cause significant business disruption across all areas of the business and at all stages of transactions. So it requires increased time and effort for management to ensure sanctions compliance, as well as to deal with the fallout for any breaches, including regulatory issues. It requires increased costs to secure compliance. The task of vetting counterparts and employees, I've already said, can be onerous and is ongoing. And the outcome of that vetting process of itself may mean that as a business, you have to turn down potential business opportunities, or in fact have business opportunities that were otherwise presented to you refused. Likewise, you may have to withdraw from existing arrangements, potentially at almost no notice, and at potentially at significant cost to your business. If you're operating in a country where you're subject to both sanctions and anti-sanctions legislation, you can easily find yourself in an impossible catch-22 situation, and even face the practical possibility, which is extreme, but I have seen done, of having to withdraw entirely from one or other nation to avoid incurring liability or exposing your workforce to risk. And likewise, depending on the nature of the sanctions, you could overnight find that your assets and investments in certain states have been targeted by sanctions and potentially frozen. And it goes without saying, it has a significant impact on your operations and ability to comply with ongoing contractual obligations. And of course, if you get things wrong, then there's the risk of severe penalties, including regulatory investigations, adverse publicity, and potentially criminal liability. And so while sanctions may well be seen to, and to some level necessarily do, promote ethical behavior and improve sustainability, it's unquestionable that this doesn't come without a potentially significant cost to business. That said, moving forward, to me at least, the reality is that the issue of sanctions and the use of sanctions as a political tool to promote foreign policy, it simply isn't going to go away, nor is the necessity for businesses to operate in a sustainable way. And so businesses have no option moving forward than to straddle that line between ensuring and enforcing a sanctions compliance culture on the one hand, with the sustainability that that brings, and running the gauntlet of falling foul of the consequences of sanctions should they become embroiled in them. So with that, I'll hand over to Karis.
Thank you so much, Gareth. I thought you brought up the multi-layered nature of the issue very well, right? It is everything from politics, law, risk management, and really ultimately how that shapes the conduct of businesses. Well, Romesh, over to you. From one minefield to another, then corruption is next.
Thank you, Karis. And can you see my screen? Yep, excellent. Okay, well, thank you for the invitation. Thank you for your patience with my late submission of the points I'd like to speak on. But it's as you said, it's a minefield, very interesting, and also we're at, I think, a stage where it's developing quite rapidly. So especially this week, we're at a very appropriate stage to discuss corruption. So I'm going to take you through very quickly what basically corruption is in terms of international law. Now, there are many points that I could have covered, but I'm just trying to stick to the basics. I'll first start off with an introduction using the Transparency International Corruption Index, and also some points on Singapore law on corruption. And then I'll touch upon the UN Convention Against Corruption. I know there's an OECD anti-bribery convention, but we just don't have time to cover all of these. I'll also talk about the UN Global Compact and what it has to say about corruption, also UN Sustainable Development Goals. And finally, I'm going to look at a very interesting area that's uncodified, and essentially it's the general international law principle of international public policy against corruption. So we'll cover a lot of different areas. And just to start with, I thought that I should really quote, and I know we don't have that much time, but I thought I was moved by this. It's the late, great Kofi Annan, and his foreword to the UN Corruption Convention. He said, "Corruption is an insidious plague that has a wide range of corrosive effects on societies. It undermines democracy and the rule of law, leads to violations of human rights, distorts markets, erodes the quality of life, and allows organized crime, terrorism, and other threats to human security to flourish." He also adds, "This is an evil phenomenon, and it's found in all countries, big or small, rich or poor, but it is in the developing world that its effects are most destructive. Corruption hurts the poor disproportionately by diverting funds intended for development, undermining a government's ability to provide basic services, feeding inequality and injustice, and discouraging foreign aid and investment. Corruption is a key element in economic underperformance and a major obstacle to poverty alleviation and development." I think that sets a really nice wide range of topics that corruption just permeates, and so it's a very good starting point to see how sort of what an effect corruption has. It's a small concept, but it has a wide-ranging consequences. Now, just to show what's happening especially in the Asian region. In terms of corruption on the ground, one of the big issues with corruption is it's very hard to detect. No one's going to admit, "Oh, I was involved with corruption." So it's very hard to sort of understand exactly what's going on the ground. But an often used index is the Transparency International Corruption Perceptions Index. And they use an aggregate of a number of different reports and indexes on corruption and try to sort of key together what they think is sort of this sort of aggregate ranking, and obviously it's not a perfect solution, but there you have it. It's quoted often, and you see what I see in this table is, Asia is not just, or Asia Pac is not just, a group of developing countries. It's also has developed countries that are in the top of the rankings for the lack of corruption. So you'll see Singapore, Hong Kong, and Japan here as being, in the top sort of 10 or 20 countries. But if you go down the list, you get more, also you get states. But in the next screen, you'll see the bottom end of the list. And you'll see again, a number of Asian states are featured here. Worst in Asia would be North Korea. it would be, placed 170th on the world rankings. So that's pretty low. Cambodia also is pretty low. Afghanistan, Bangladesh, Myanmar also ranking quite low, which is an indication. I'm not saying this is a perfect type of science, but it's an indication about the level of corruption in some of these countries. Now, I'm based in Singapore. Just to show what happens in Singapore in terms of the local legislative framework. Each country has its own, but for Singapore, you've got two main acts that deal with corruption: the Prevention of Corruption Act and the Penal Code, and they provide for both bribery in the civil. Bribery and corruption in civil sort of context, and also in the criminal context. Another point that us as international lawyers would be interested in is the scope is extraterritorial. So if you're a Singaporean, but your act of corruption that takes place in outside of Singapore, the acts will still cover you and those acts that you've committed. Another act indirectly that's related to corruption is the Companies Act. It requires, the sort of corporate records to be kept that will sufficiently explain transactions in a way that reduces the ability of a corporate entity to, engage in corruption or bribery. And finally, I just want to mention the Corrupt Practices Investigation Bureau. You see a lot of the corruption, we're looking at the UN conventions, they were sort of early 2000s, that sort of time frame. But the Corrupt Practices Investigation Bureau is one of the earliest bureaus that was established in 1952 in Singapore, and it sort of shows Singapore's emphasis on trying to contain or prevent corruption, and they have a long history of that. Now, turning to the UN Convention Against Corruption, as I mentioned, it was adopted in 2003, entered into force in 2005. I was quite surprised. 188 states are parties to the convention. That's a very significant number. And Singapore ratified it in 2009. It goes through many provisions. It's one of those documents, a stapler can't sort of staple through it. It's quite big. It's like 40, 50 pages long, but it's got a number of chapters, and all of these chapters, essentially, these are the obligations of states that sign on to the Corruption Convention. You've got preventative measures, i.e. states need to develop anti-corruption policies, legal instruments, measures, to ensure that public officials and the private sector do not engage in corruption. Then you have a section that specifies that states need to develop laws that criminalize corruption. And then another chapter emphasizes international cooperation and how, maybe the courts of one state could render judicial assistance to another state where there have been relevant corrupt practices taking place extraterritorially. And also it deals with asset recovery, how to try and reclaim the monies that have been used in this illicit way. Now, again, very quick overview. So now I'm moving on to the global UN Global Compact. And this is really an instrument that businesses have started to use. And there is a specific principle, and it's called anti-corruption, and I quote, "Businesses should work against corruption in all its forms, excluding extortion and, including extortion and bribery." Now, the way this works is there's this implementation process. Now, when I logged on this morning, there were over 14,000 participating companies in this program. But what happens is that every year they need to report, right? So they have this that's the external requirement. And you can find that and I'm happy to have these slides circulated. You can find that at the link that I've provided there. But that provides every year the reports of each of these 14,000 companies. So and these these reports are quite significant. They can go up to 50 pages. So they're very detailed, and it shows companies do spend a lot of time on this, and they're very, they're quite, some of them are very glossy 50-page reports. But also the internal requirement is to try and institute these anti-corruption policies within the enterprise. But that comes out in the report saying we did this, this, and this year to prevent corruption, or to ensure that our employees knew about the what is corruption and the effects of corruption. Now, I'll just give you an example. This is the report that Prudential submitted, and this is their 2020 report, and it's about 50 pages long. So if you look through it, you go through all the different sort of UN Global Compact principles, and there'll be one is corruption. And so Prudential reported this in 2020 that that they take fight against money laundering, terrorist financing, bribery, corruption, fraud seriously, committed to implementing, and then they had their own code of business conduct, and that highlights corruption, and then they go through the preventative actions that they've been taking, and then finally they report on how many instances. This says 0. It'd be very interesting to go through all 14,000 of these reports, if anyone has the time, and see how many companies actually report that they have instances of corruption. But this is the type of report that's given. But you'll see that's page 35 of the report. But there are many other pages to this report as well. So that's the global compact in action. This is where states sort of say, okay, this is what we've tried to do in relation to corruption, but many other of the other principles. So you've got labor, you've got environment, and I think you also have human rights. So they're all addressed, and it'd be interesting to hear what Anita has to say about the reporting obligations under the UN Global Compact, if we have time. Next, I move on to the UN Sustainable Goals. Essentially, the Global Compact was essentially for corporate entities. This is more diverse. It's for businesses and also member states. But the whole, all of these sustainable goals are expressed in very sort of general terms in the goal, but then the targets are much more specific. So the target 16.5, which relates to goal 16, requires substantially reduce corruption and bribery in all their forms. Now, one of the ways that bribery and corruption is fleshed out in these is this proportionality requirement. I won't go into that, but I'll show you the next slide, which helps illustrate how this sort of measurement takes place. And it's a very interesting slide. So you look at this proportionality, and this is from the United Nations Office on Drugs and Crime. I couldn't find out the date that this was, but it's a very interesting statistic. So the prevalence of bribery. So they look at Nigerian adults, and they say 52% of Nigerian adults had contact with public officials. Of those 52%, right, 32% of them were paid, or 32% of them paid or were asked to pay a bribe, right? So that's the sort of way that this, and as I said before, it's very difficult to actually put your finger on how much bribery takes place, because no one's going to admit it openly. But this is one way that the general principles, sustainable development goals try and measure what's happening out there. Now, just given time, I just want to move on to my last topic, which I think links up with all of this very well, is investment arbitration has a concept of obviously corruption in two ways. The first is it could be actually expressly or expressly mentioned in the BIT or the investment treaty, right, by what's called a legality requirement. And usually the legality requirement says that your investment must be made in accordance with the host state laws, right? So that's the legality requirement. But that's been interpreted in very different ways. And one way it's been interpreted is, obviously, if you engage in bribery, you have breached the local code or the local laws on bribery. Therefore, you have breached the legality requirement, and therefore your investment is not protected under an investment treaty. That's what happened in metal tech, right? So, and the claim was thrown out on jurisdiction. Sorry, I'm not sure exactly if it was on jurisdiction or was it admissibility, but the claim was not allowed to go forward, and each party had to bear their own costs. Now, another very different way of this type of situation panned out in Spentex, again against Uzbekistan. In this case, there was no legality requirement in the investment treaty, but the investor had been involved in corrupt activities in procuring the investment, right? And the tribunal said, even though the BIT does not have a legality requirement, right, your investment is not protected, right? Because you've engaged in this sort of corrupt activity, and that is not covered by the BIT. Tribunal went on, and this is very interesting. The tribunal went on to look at, well, what about the state's conduct as well? And it said it takes two to tango. You've got, a private entity offering the bribe, but then you've got a government official taking the bribe. So you've got two parties here, the investor and the state, engaged in the corrupt practice. So that the tribunal sort of spent a lot of time looking at this issue. And I should just note that this case is not reported. A lot of this information comes from investment arbitration report or global arbitration review. So I haven't seen the report, but this is what's been reported. And the tribunal here said, okay, they looked at the conduct of Uzbekistan and said, well, it refused to prosecute or investigate these allegations of corruption. So in a way, there was some sort of contribution by Uzbekistan. And there's been a lot of debate about this. What happens? You've got a state that engages in corruption as well as the investor. What do you do? Now, this is quite unique. What the solution that was produced by this tribunal was quite unique, because previously it was just basically investor's claim got thrown out. The investor had to pay its own costs, or sometimes the costs of the state. In this case, the majority decision said that we recognize that Uzbekistan has taken part in these corrupt activities as well. It's failed to prosecute, it's failed to investigate. What we're going to do is we're going to tell them we've got wide powers to order costs. So using those wide powers, we're going to urge Uzbekistan to donate $8 million to a UNDP anti-corruption project. And if it doesn't do that, the order will stand that they will have to pay 75% of the cost of the claimant. And I think that 75 was about $15 million. So that was the decision of the tribunal. Uzbekistan actually paid, the report says, the $8 million to the UNDP. So it's a very interesting way of looking at it, whether you agree or disagree, but it's a very apt sort of way of finishing my presentation, because I think, again, we start off looking at the investor, but we've ended up here with, an investment tribunal looking both the investor and the state conduct. So it's a very interesting development, but I think I haven't seen a case that's followed this, but it's going to be interesting to see what other tribunals do. So with that, I'll hand it back to you, Karis.
Thank you so much, Romesh. I have to say, I am wrong. I thought that we would be in for a treat, but this was a buffet. And I felt like my brain just expanded listening to the four of you. Now, let's start off with our panel discussion. And we do have one question in the Q&A box that I'll pick up in the course of our discussion. Now, let's start with the role of international law, what impact it has had, and pick up some of what the speakers have talked about in terms of accountability. And Romesh, I liked your inspirational quote from Kofi Annan, right? Some of these things that we are talking about, like corruption, it's corrosive, it permeates society, it is destructive. So if we think about the role of international law, what do you think its role is? Is it about the bare minimum of protections, or is it about providing a more robust standard? And here maybe I can call on Anita to comment first, right? Because one of the things you said about the business and human rights guiding principles, you said they're very pragmatic, they're intended to address governance gaps, right? So really, is there a trend? You know, do you have comments on what you think the role of international law is, should be? Is it increasingly regulating more private activity?
I think it's a complex issue. And so if we contrast anti-corruption with business and human rights, we have, I think, two different models. With anti-corruption, it took time. We began with the US Foreign Corrupt Practices Act, and over time moved towards this international consensus around the United Nations Convention Against Corruption, which we just heard about from Romesh. So I think that was a trajectory where it took time to build consensus around what should be hard rules and a sort of general consensus. Now there's a different issue, and we could debate for a long time whether having international rules and binding law actually is enough, because again, as we've looked with the publication of the Pandora Papers just a couple of weeks ago, right, we just really see that there are still just strong gaps and governance gaps in the area of corruption. But back to business and human rights, I think the challenge here is that the guiding principles were meant to be a way for states to sort of start to move into regulation while at the same time asking business to do more. The Global Compact preceded the guiding principles, but it's a voluntary initiative. We just published a report to the Human Rights Council looking at 10 years of implementation of the guiding principles. And what we found was that there's a strong normative commitment, but that in terms of businesses, that soft law hasn't worked enough. So the answer is, to some extent, that we do need some regulatory frameworks, and we're starting to see that. I think the big challenge is we don't know what are the right models. In the area of corruption, we had state practice. It took time and state practice and a variety of instruments, including the OECD Convention, before we got to a UN treaty. And so knowing what kind of regulation and what kind of rules actually work globally and where there can be consensus, I think, is very important before we move to a treaty-based model. And that's where I think we have a challenge with business and human rights, is that we're moving towards needing that regulation, but yet we don't know what the model should be. What's the recipe yet?
So it seems like there's a bit of a continuum, whether it's in terms of the frameworks or even for different areas, isn't it? Anyone else? Does any other speaker have a comment?
I agree with what Anita was just saying. I think consensus is really important. In my view, international law should always be looking to push the boundaries, to raise the standards. But unless you have consensus, then it's meaningless. And I think that's why corruption on some levels has been so successful. Sanctions less so, because I think they're more fragmented. But the buy-in on the corruption side is not unanimous, but it's sufficient such that if any state is not buying it, then there's significant pressure on it to do so and to adapt its laws and to improve its regimes. But without consensus, then the international law can be as strict as you like, but it's to some levels meaningless.
Maybe I could jump in. Yeah, just to broaden the conversation, I agree with what was said, but I have a problem with just classifying everything as voluntary and soft law and everything, because yes, it's voluntary, but once you have subscribed to the code, to the Global Compact, to sets of guidelines and so on, you've committed to something. And I think that there are legal effects to this commitment. And I think that there is a need for further exploration about that. At least, states hold to the principle of good faith, and I think private actors should also be held to this principle. That's it's something then legal effects. I think that Romesh concluded with investment arbitration. We can speak of commercial arbitration. It seems to me that, you know, when there will be a discussion about the behavior of the private sector, you also have to take into account what are the codes of conduct to which the private sector in question has committed, what it has done, and so on. So it's all to say that I don't think we're anymore in the soft law area. We're in an area where we have sort of to figure out what is the legal language to capture these commitments. But there are legal effects for me. And it seems to me that domestic law is very important. And I think that we should strengthen as much as we can the capacities of states so that they can adjust their domestic legal orders to their international commitments. But as I've said, now states are sort of, and they've accepted it, bypassed in a way that the private sector is directly targeted by international instruments. So if they are targeted, if they accept this targeting, then, you know, there is this responsibilization and accountability which should come into the picture. And so I'm not saying that we are yet at a stage where we can speak of legal engagement of the responsibility of the private sector for not abiding to these principles and codes of conduct. But there are other legal effects that could be explored, and it would, I think, level the playing field.
So I want to stay with
I'll just jump in for 10 seconds to say, and just pick up on what Laurent said, which is that in the area of business and human rights, for example, if a company commits to the guiding principles, this is now something that's being litigated by plaintiffs, lawyers, to say it creates a duty of care in tort litigation. Again, I think the larger challenge is that it takes quite a bit of time to really unpack what are the legal effects of these kinds of corporate commitments and codes. So I agree that there is effect. I think the question is just how one really interprets, and different courts are going to have, I think, differing views on that.
Can I just add one brief point? When I studied international law way back, it was just basically states. States were sort of the actors of international law. That was it. I think we're living now in an era of stakeholder sort of ownership of all of these concepts, and it's not just international law. It's you know, you look at a company and the rights of shareholders and all of these sorts of different issues. Stakeholders are now becoming part of the framework, and that's really starting to affect how people interpret and apply all of the concepts we used to apply in that very sort of unilateral way of that, you know, only one party is involved. But now it's not just a party, it's just so many different elements of society that are involved.
And that all of those mentioned.
Sorry. But just to say, I mean, just if you look at corporations, for example, most international reputable corporations, if you look at their compliance manuals, they will always apply the highest denominator for any of the areas we're talking about here, whatever the local laws may allow and permit, they will themselves require the highest. So if corruption, if you have any element of the state, then you'll look to compliance with the FCPA, with the gold standard of compliance, rather than local laws, which may be more lax.
All of those interventions dovetailed perfectly. I think we do want to pick up on the idea of responsibilization, Laurence, that you mentioned, and really what it is to me is accountability. You know, so maybe we can pick up a bit on the accountability of states and accountability of private actors. And I open this for your reflections in the respective fields that you have considered, whether it's environment, sanctions, corruption, human rights. Is there accountability? How do you see it being implemented or demonstrated? And here, Romesh, if I can put you on the spot later, I mean, one of the things you mentioned is the UN Convention Against Corruption. 188 state parties. I'm sure someone somewhere will be able to make an argument on customary international law and whether there's a sufficient state practice and opinio juris. But, you know, do you think that treaty has contributed, for instance, to accountability in the field of corruption, do you think? Open to anyone for their interventions. Romesh, you're muted, yeah.
Just on that point, one of the cases, or a couple of the cases, right? There was not a definition in the BIT of what constituted corruption. So the tribunals actually referred to the UN Convention and also the OECD Anti-Bribery Convention and used that as their definition of corruption. So in that's starting to become practice, and that's one of the sort of let's see how it develops. But I think definitely the structure's in place for some sort of argument about customary international law to take place. I think everyone's I think on one sort of hymn sheet that corruption is not good. The question is, what is corruption? And in these investment claims, you have the just the black and white corruption. You leave a box, a suitcase full of cash in the Prime Minister's office, and when you leave with the suitcase, it's empty. That's corruption. But if you're hiring consultants, where does the corruption take place? How much do you have to pay for that to become corruption? But the definition, I think, that's not going to become customary international law, I think, given the difficulty of how you measure what is corruption.
Any other reflections on accountability in the field?
So maybe from the perspective of investment arbitration, you could consider that maybe in a legal framework, if there is a counterclaim, there could be room for legal accountability in some respect. Would you have the standards? Because that's then there's the question, what is the breach of which standard and so on. But I wanted to ask a question to Gareth in terms of, because he spoke about the notion of reputation. Is it something to be considered as something powerful? Because in a way, it would be peer pressure that if you don't behave in accordance with your commitments, then you would put at risk your reputation, and that could be something that could mobilize the energies of all the actors.
Gareth, can I impose on you to add on a second limb to that question, because it's closely related? I mean, how do you think, or how do you see the impact that these laws on sanctions have on the private sector? Do you think it has been very clear and direct impact, right? I mean, one of the things you've mentioned was risk management, how sanctions have actually and practically impacted on the behavior of businesses, and sometimes they have been forced to give up opportunities. So maybe your reflections on all of the above would be great.
Absolutely. Dealing with reputation, certainly in my practice, the clients we deal with, reputation is key. And if you have a damaged reputation, because, I mean, obviously things can happen to any organization, even the best run with the best compliance regimes known to man. But the fact is, if you have a lax regime, you turn a blind eye. Corporations, the businesses are very, very concerned at the impacts that can have, because it doesn't just have an impact in terms of bad press publicity. It has an impact on how you're seen by regulators throughout the world, potential fines that are imposed, potential prohibition on carrying out business, losing business, because we're talking about sustainability. It's not a one-way street. If you have carried out any activity that breaches some of the areas that we've been discussing, then in due diligence that you're facing when you're entering a transaction, you have to disclose that, and you can lose out on opportunities. So I think reputation, albeit slightly nebulous, is in fact a very, very important tool in shifting behavior. In terms of impact of all of this on the private sector, I mean, undoubtedly sanctions increasingly play a massive role. We have a very large sanctions practice, primarily based in Washington, but throughout our network, and that it continues to grow. And I think that is a reflection of the fact that sanctions and dealing with sanctions is increasingly an issue that businesses are having to address. Because as I said in the presentation, getting it wrong, the consequences are very serious. And an important part of this actually ties into the accountability because, as I say, senior management are to be held accountable for any wrongdoings. And certainly, for example, it's slightly different, but in a Hong Kong context, I've done a lot of work for financial institutions. And the regulators here have shifted from corporate responsibility to individual accountability. So if anything goes wrong, the regulators want to know who within the institution was responsible for that, who knew what when, and who will be held accountable at a senior management level. And when individuals face liability or the prospect of liability, that shifts corporate behavior because obviously no one wants to have that liability themselves. And so I think all of this is a very, very powerful tool. It can be a very slow moving tool, but it's very powerful.
So let's pick up on the idea of the tool and talk about the effectiveness in your views of whether it's international law or domestic law in each of these fields, right? So maybe let's take the stick first. We'll talk about the carrot later, but the stick first. So do you think that international law or domestic law has been effective in deterring certain conduct, right? The easy one we mentioned just now is sanctions because it tends to be a bit more hard law, right? Has it been effective in maybe deterring targeted states from human rights abusers? And this is in fact one of the questions that has arisen. How does Gareth view the role of trade sanctions in promoting labor rights in a third country? So maybe Gareth, at some point you can respond with your reflections, but it's equally to all other speakers, right? Do you think it has been effective in deterring certain behavior, shaping that behavior?
Maybe if I may, I could start. In the field of environment, I think that unfortunately, I think we're still at a stage where we're framing the conduct of all actors, be they states, international organizations, private sector, and so on. And so that means that the norms as we see them are not that prescriptive, okay? And so quite often it's difficult to test the behavior in light of these norms. So what I would say is that, yes, I think that we have had some effects at the domestic level. And I would say that I'm very admirative of the domestic judges because they've been quite creative for making sense of what states are doing with environmental protection. So to put pressure on some actors, not just the private sector, but other actors, okay? But at the international level, and hopefully we will do something which will be, there will be an outcome of the Glasgow meeting, but we need to strengthen the commitments if we want to take all the actors to their words. So that would be the perspective from the environment.
Yeah, and on the human rights side, and this really links back, Karis, to your prior question about accountability. The larger issue and why we have the guiding principles was because victims of transnational human rights abuses didn't really have anywhere to go, either in their own jurisdiction or globally, to seek access to remedy. Sadly, that's still the larger problem, right? That we have greater emphasis, I think, on human rights due diligence, and hopefully that means there's prevention of lots of human rights related impacts, but we still don't have accountability in the larger sense. The one stick that we're seeing now that's interesting and appears to be working, whether it's the right stick or not, relates to the issue of customs and trade related enforcement. In the area of forced labor and modern slavery, we have a variety of jurisdictions, the US being the first, to basically stop goods at the border if there's credible allegations that they are in any way made with forced labor. And so this is and again, having an impact, immediate impact on the economics for large companies who need to get their goods into markets, and also and then on the behavior that they have in terms of stopping that. So I think that's an example of a stick that appears to be one that is working.
Excuse me, on sanctions, I mean, I think they definitely can be impactful, in particular if there's consensus. But it kind of goes to the point that I was making earlier, that frequently sanctions are used as some sort of political maneuvering to put forward a political message And even if sanctions are imposed, it will, if that's the circumstance that they're imposed, then it won't necessarily shift behavior. So, in the last year and a half, we've seen tit-for-tat sanctions between the US and China over various issues. Now, with not debating the rights or wrongs of those at all, but I don't think any of those sanctions have shifted either side's behavior and would be seen by some as political maneuvering rather than shifting any behavior. So I think they can be impactful, but I think it depends on the issue that's being addressed and the level of consensus regarding their implementation.
So Gareth, you've actually, I think, indirectly already touched upon another of the questions that has been posed in the chat. What levers are there to prevent powerful states from weaponizing sanctions as a tool to further geopolitical interests? And I think, sorry, go ahead. You're about to unmute.
No, I'm very, because if others have, I'm sure others have views on this. I'm very, very happy to hear those first. I mean, ultimately, my view is it can be difficult because I do think that increasingly they are being used for geopolitical objectives, and maybe moving away from some of what would have been seen in the earlier traditional sanctions that were aimed more at sort of the human rights abuses that applied. But I'm very happy for others to give a view.
Well, I have just a question back to you, Gareth, about that, which is that, and of course, I think the geopolitical challenges that you're mentioning are a bit different than, just as you're saying, the sort of historical nature of sanctions, which are meant to deal with human rights. I deal with companies that are dealing with gray zones. So if they're dealing with Myanmar or another situation where there's a conflict, where there are human rights issues, they're in a gray zone where they have these guidance from the guiding principles and others as to what they're meant to do, but there's no hard line about whether they stay or go. So to some extent, sanctions give them a red line, which may be at least more certain than where they are now, which is trying to figure out what's the risk and what's the right thing to do. So what's your view as to is that red line of sanctions, I think, preferable to sort of businesses trying to do their own risk calculation?
I think it can be. I think it usually depends on whether the business, where the business is on the risk spectrum. Certain businesses like to have certainty. Others actually like to have those grey areas that they have an opportunity to carry out what is legitimate business that they can get themselves comfortable in doing. So again, without ducking the question, I don't think there is a one size fits all. Certainly, I know certain businesses do like to have the certainties that they know the path that they're going to follow. But I wouldn't say, in my experience, that's all of them.
So just for the sake of completeness, I think that again indirectly touched on another one of the questions that have been posed, whether businesses should accept unilateral sanctions into their sustainable development or ethical business conduct paradigms. And essentially you're saying it's not a one size fits all, right? Different businesses will have to conduct their own risk assessment and how they want to manage it. Romesh, did you want to add something?
I just thought that a message I've sort of detected from a lot of our clients is that, to be sustainable, right, long term, you need to start thinking about all of these wider aspects. And the red line is not that, that important. It's more like what Gareth said before, you're trying to choose the sort of the highest types of goals to attain, rather than having that sort of red line. So in certain contexts, it's driven like that. Those sorts of red lines are driven internally by the firm, especially those firms that want to sort of are very interested in sustainability and looking towards the long term.
Let me close because you're running out of time. So a last question for anyone who might want to reflect, really. Let's talk about sustainability, the order of the day, right? And if you can gaze a bit into the crystal ball, what do you think about the legal frameworks in place? May they be improved? May they be further developed in order to promote greater sustainability in the way business is done? Any closing thoughts?
Maybe I'll start. What I think is that, and maybe it's my perspective from international law, but I think that the agenda, the 2030 agenda of 2015, bringing with it the 17 Sustainable Development Goals, should be a reference document. It was adopted unanimously by all states of the international community, and I think there are defects and there are vulnerabilities, but we should, it should be our language, and I think we should build on that and try to have as many commitments as we can, so to achieve the goals that have to be achieved by 2030. We're in an era where states don't want to commit anymore, so at least we have this agenda, and we should build on this agenda.
So it remains for me to thank all the speakers, Gareth, Anita, Laurence, Romesh. It was extremely engaging. I really enjoyed the intellectual stimulation. That's what I feel like my brain has done. It's gone to the gym and come back after an hour's workout. So I feel like in local terms, I have much to tapao with me. I have much to take away with me. Thank you to you, the participants, for staying with us. Thank you for your interjections, comments, and questions. And a final plug for those of you who are not yet members of the International Law Association Singapore branch. These are events that we have organized, and this is what we stand for. We strive to provide a platform for open discourse between government officials, academics, practitioners on topics of international law. We try to find points of commonality, but also to seek exchanges where views intersect. So please do sign up, look us up, the ILA branch Singapore. Join us, and we look forward to welcoming you at our future events. Have a lovely rest of the week, everyone. Bye-bye then.